bit more on contempt of court, 'cause it's obviously a very topical subject at the moment. Dan's done a really good video about all sort of nitty-gritty of the law, but I just wanted to talk a bit more generally. I've seen in my other video, I've explained that under the Contempt of Court Act, there's this what we call strict liability publishing rule, which is if proceedings are active, and that means somebody's been arrested and stroke or charged, then if you publish anything, and publish is a very wide thing, it just means to put information out there, it's not necessarily in writing, because it can be tweets, it can be commenting, then if your actions prejudice a trial or risk prejudicing a trial, you are guilty of the offence, subject to certain defences, such as innocent publication, you know, accidentally talk about it and somebody hears, or there's that Section 5 thing, which is it's a good faith discussion on matters of general public interest. But obviously, the more you speak about a specific case, then the less likelihood of that actually applying. But what about when proceedings aren't active? Nobody's been charged or arrested yet. Under the common law, you could still commit contempt. You could still commit contempt. But the intention required was that you actually had to intend to prejudice the trial. You know, it wasn't a strict liability offence. It was like, yes, you have chosen to do something with the intention of prejudicing the trial. Although, as we've said with intention, it can be, we can infer intent from your actions, and if something is a logical consequence of your voluntary act, you can be deemed to have attempted it. So the Attorney General at the moment is saying, you know, that is the situation. So even though certain people have not yet been charged, stop commenting because it could still be contempt. Some people, however, especially in the press, perhaps understandably, are arguing that the old common law thing doesn't apply anymore. So they're saying it only applies to active proceedings. And why are they saying that? Well, they're saying that when the Act came out, the 81 Act, that effectively superseded the common law. It's what we call implied repeal. Now, some actual acts, you know, acts that replace legislation, that's very simple. This act replaces previous act or section whatever of a previous act. You can identify it. It's a bit harder to repeal common law things because, you know, it's all case law and it's all open to interpretation. But it does happen. The 2013 Defamation Act, for instance, explicitly says the old common law Reynolds defence has been abolished. And Reynolds was a case that set out a particular test for how you do journalism. So that was actually, you know, explicitly repealed. But the idea of implied repeal is if an act deals with something that a previous act or a previous case law dealt with, then the fact that Parliament has gone to the trouble of producing this legislation means that basically the old law has been superseded. And that is the argument that the press are currently making. They're saying, well, actually, the 1981 Act, basically, that's everything you need to know about contempt, and all the old common law stuff has vanished. Interesting little thing about implied repeal. Witchcraft used to be illegal in this country, as you probably know. Then they brought out an act that said, okay, witchcraft is no longer illegal. We're not, you know, hanging people or burning them. But it covered what we call fraudulent mediums. And that said, basically, you couldn't charge money for performing supernatural services. But then, of course, you've got all your Doris Stokes type people, you know, and it became just popular entertainment. And people said, well, hang on a minute, if people want to pay their money, you know, for a bit of a night out, what's the problem? So they were going to repeal the Fraudulent Mediums Act. But the problem there is somebody pointed out and said, well, hang on, if we just say this act is abolished, that means everything that act did is abolished, including abolishing the old witchcraft offences. So all of a sudden witchcraft becomes, you know, the law again, and you risk everybody being sort of like, you know, burnt at the stake. In the end, that was actually just dealt with under some consumer regulations. So, you know, you can now charge for your sort of tarot reading services. But I just thought you might find that interesting as to what the issue here is. So, is somebody going to risk being the test case on this? Because like I said, the Attorney General who, you know, is the person who authorises such prosecutions, she, as far as she's concerned, she thinks the common law still applies. The press think it doesn't. So yeah, let's watch this space and find out. And you'll notice I didn't comment about any particular case in there, just in case, because I don't want to be the test case. Anyway, if you found that useful, interesting, or whatever, please consider liking. And like I say, if you wouldn't mind subscribing, because apparently lots of people who watch my videos aren't subscribers. So feel free to click whatever button does that.